there's always some stuff that I have difficulty with, but it was relatively easy to work through it with her today. So yeah, so the full-on progression, it goes from a butterfly guard, a butterfly flip rather, to where you're popping your opponent up, ashigurami, sweep. And she was having some difficulty on the sweep, and there was one thing I was going to suggest to her, because she has shorter legs, that I think might have worked out a little better as far as a takedown technique goes. And so instead of having the left foot up on the hip from the outside, what if she were to take her right foot and come in from the inside of the top of the thigh there? I mean, because technically I don't think that's reaping. But then after you get that foot up there, to swing the other foot out and around and hit the back of the knee with it. And so you're swinging at the back of the knee or the heel with your heel. You're on this case it would be the left heel, and pushing them away with the right heel. And I thought to suggest that to her, but I never got around to it, because she found another way around that she was just as easily taking me down with. So she didn't have any trouble taking me down. I mean, after she figured this out, I think she was doing like an outside ashi or an inside ashi on the other leg. Like if I brought it far enough up, she grabbed the heel of the foot, and instead of hooking the knee, bringing that up towards my buttock, and putting her other leg on that side. I can't remember exactly how she did it, but she took me down twice with the damn thing, so it works. And I mean, I'm considerably larger than her. She was, I think, like 5'1", 5'2", maybe $120, maybe $130. I mean, she was kind of stocky too, but she had shorter legs and arms than I did. So, but that's an advantage and a disadvantage. I mean, it's a disadvantage with regard to keeping your opponent distant from you and a few other things. But when you're trying to keep your opponent close to you, when you're trying to contain your opponent, when you're trying to slow things down, having smaller limbs like that isn't necessarily a bad thing. And I don't know. I typically end up with partners that are bigger and heavier than I am. And that's just fine by me, because I know that if I ever do competition again, I'm probably going to get somebody that's bigger and heavier than I am, and probably more skilled too. Anyway, point being that I got to get used to players that are bigger than me and dealing with players that are bigger than me, because, as I said, I expect that the statistical likelihood is that my opponent will at least be taller than I am. I mean, when you get up over 200 pounds, there's only two ways to go: up or out. Well, most people that go out, that are real fat and chunky, they don't tend to do jujitsu. I mean, there's always a heavier guy, such as myself, now and then, that gets in on the mix. But if somebody's 200 pounds and they're male, chances are they're somewhere between, I would say, 5'10" and 6 foot something. And I mean, that's just the range. Statistically, that is the range. And so, like I said, finding somebody that I'm going to end up competing with, they're going to be like 200 and something pounds. They're probably going to be over 5'8", and they won't just be over 200 pounds. Like, I'll just be over 200 pounds. They'll be way over 200 pounds, and I'm having to fight like underweight. if you were a middleweight, this would be like fighting a heavy middle heavyweight or a heavyweight. You know, in weight terms. But that's my luck. You know, I mean, if I were to drop down really, really low, I don't know how I would have to change my game any. You know, I don't know that I would be terribly much weaker than I currently am, but I probably wouldn't be carrying around as much muscle. I mean, because the stuff does weigh something. I mean, I've been really lean once, and I was fucking wire. And oddly enough, I didn't have the kind of definition that I have now, which is weird. I mean, I was in way better shape back then as far as, like, cardiovascular wise and whatnot. So, I don't know. So, it's a weird asymmetry there. Anyway, let's go ahead and throw down with some music. And this first one, I thought about it long and hard, how I wanted to start this one. And this one's going to go out to all of you who have been taking part in the short squeezes going on out there. May you hammer this shit out of silver and fuck up JP Morgan sometime soon. Anyway, and so for you guys in particular, I was thinking about this song and I think it's so appropriate for you, and so here it is. Body Count, Bum Rush, First Dance, here on Coin Metal. And that was Prong with Rude Awakening. And so, speaking of, you guys have been probably seeing it out in the normie news these days, that the people of Wall Street just are kind of pissed that you're getting in on their action. Well, I got this to say about it. There's nothing to be done about it. You know, I spent a lot of time this last week poning the SEC on Twitter, basically pointing at them and saying, look, man, there's all this shit going on in legitimate markets, in regular markets, and you just fucking ignore all of it. All the incestuous relationships, like between Robinhood and Citadel and so on and so forth. You ignore all that shit. You know, there's no antitrust there. You've just got Robinhood acting as a proxy for the hedge fund that their clients are currently extorting out all the money from. But like, it's like, if these laws, you know, antitrust laws, if they mean anything, they mean that you should not have the hedge fund or hedge fund manager or their processor processing transactions for a trading platform that's open to the public. And, I mean, because they're going to be trading against the securities that are held in the hedge fund, and that goes against the hedge fund's interest. And so they just say, oh, we're just going to stop trading on GAME. You can't do that anymore. You can't trade GameStop anymore. What the fuck is that? I mean, if you're going to step your foot into the market, you deal with the bulls and the bears, kid. There's this kind of protectionism is just, it's completely antithetical to free market capitalism, man. I mean, you know, you're supposed to be acting as this like, I don't know how to put it, like a billboard to the rest of the world, what these companies are worth in relative terms, and you're fucking up. So anyway, got this thing here. Wall Street Bets is Occupy Wall Street with Teeth. CoinDesk Podcast Network. Oh, shit. Damn it, Jim. I hate it when they do that. Well, they at least put up the bullet points, so we'll cover those really quick. This is by Nathaniel Whitmore. So yes, penis. The retail trader insurgency has massive implications for the future of capital markets. This episode, blah, blah, blah. This week, a collective foul-mouthed internet memers took down some of Wall Street's best-known hedge funds. In today's episode, NLW looks at Number one, the historical context of how great the financial crisis set the stage for Wall Street bets. Number two, how WSB gained infamy during the COVID-19 crisis by correctly predicting the market's rebound while other investors remained bearish. Number three, why WSB started going after short sellers, particularly around gain. Let's see. 4. How WSB forced a short squeeze that required Melvin Capital to call in nearly $3 billion of emergency capital. And number 5. Why Robinhood forcing users to stop buying GameStop and other related assets will go down as an inflection point in the history of capital markets. And that is absolutely true. And there's another one right after this. It's on CoinDesk, and we're gonna go with this one because it's an actual story instead of a fucking podcast commercial. So this is on CoinDesk. Retail traders sue Robinhood over meme stock restrictions. GameStop. Let's see here. This is on written by Danny Nelson, and judging from the picture and the name, yes, penis. January 28th, 2021 at 10:56 a.m. PST. Retail traders in 2 U.S. states sued Robinhood Markets Thursday over its decision to prevent buy orders on GameStop and other so-called, quote, meme stocks swept up in the Reddit-fueled trading frenzy. The separate suits slam Robinhood over a decision that had immediate repercussions for impacted shares. GameStop, which had been soaring for days on short squeezing and mass speculation, began tumbling downward after Robinhood, a major retail trading hub, implemented the hold. Massachusetts resident Brendan Nelson alleged Robinhood tried to, quote, slow the growth of GME without legitimate cause. A move he said benefits Robinhood's institutional investors over its clients in violation of its customer agreement. He filed a class action suit in New York federal court. The other case, filed by Richard Joseph Gates in Chicago federal court, alleged Robinhood, quote, caused irreparable harm to retail traders of Nokia, AMC Theaters, and BlackBerry when it disabled buy orders on Thursday, according to Bloomberg. And that's absolutely correct. And not only that, you're really damaging the reputation of the quote-unquote legitimate markets. I mean, when this kind of manipulation can go on, where all of a sudden I can't trade via Robinhood because of some incestuous relationship in the background, where the payment processor literally won't take the fucking orders. And that's the thing, is like they're trying to pin it all on Robinhood, and ultimately it is their thing, I think, because they should have been looking for another payment processor, or another trade processor rather, because I don't think they submit their own trades. They have somebody else doing it for them. I'm pretty sure it's Citadel. Let me look this up really quick. It seems to me like there's a incestuous relationship involving Reddit as well on this one. Citadel, Robinhood, Reddit. Let's look that up. And of course I'm using Bing. It's fucking... Oh, here we go. It's on the Washington Post, and hopefully we'll be able to read it. No, we can't, because they're a bunch of greedy assholes. And we're not going to... Let's see. Where is it at? Like I said, there's some sort of incestuous relationship, and like I said, I think it even involves Reddit itself. Let's see. Here we go. Alright. Here we go. This is on International Business Times, rather. Citadel owns Robinhood. Theory claims capital firm halted trading on platform as it owns hedge fund shorting GME. And this is by Manthan Chahida. Let me check and verify something really quick here. Come on. Damn it, Jim. Okay, not going to tell us. So I'm just going to go for it and say yes, penis. Anyway, this is updated on January 29th, 2021 at 1836 hours. And no indication of time zone. Damn you, Manthan. On Thursday, 28th, the popular stock trading platform Robinhood controversially halted trading of GameStop, GME, and other scripts after retail traders drove up the price of shares by, quote, short squeezing Wall Street's biggest players. Robinhood announced that retail traders would only be able to close or sell their positions on the platform. This has led to accusations of market manipulation and speculation that Robinhood is owned by capital firm Citadel, which also owns Melvin Capital, one of the hedge funds that was short selling GME. How did AMC GME stocks rally? A few weeks ago, a group of Reddit users on a subreddit called Wall Street Bets discovered that hedge funds including Melvin Capital and Citron Research held short positions, a trade in which you can expect the stock to fall and benefit from the transaction. In GameStop and the popular brick-and-mortar video game store was about to meet its financial end. However, the Reddit group's 2 million strong army was not going to let that happen. The Redditors bet against Wall Street's hedge fund, and other short sellers of GameStop, pumping up the price of GameStop from $20 earlier this month to more than $460 on Thursday. Besides GameStop, the social media users also drove up the price of other stocks, including AMC Cinemas, Bed Bath & Beyond, Nokia, etc., in what is referred to as a short squeeze. What did Robinhood do? On Thursday, Robinhood announced that it was restricting trading for the stocks that were being, quote, short squeezed, and investors would only be able to close their positions. This meant that traders would only be able to sell the stocks and not be able to purchase additional shares, causing the stocks to nosedive. The price for GME was halved today, dropping from $462 to $193.60 as of the time of this publication. Robinhood CEO Vlad Tenev said the company's decision to restrict trading in these stocks was, quote, to protect the firm and protect our customers. We had to limit buying in these stocks. Does Citadel own Robinhood and Melvin Capital? This led to outrage among retail traders who accused Robinhood of, quote, manipulating the market, and even led Ted Cruz and Alexandria AOC to agree on something. Amid the outcry, Twitter users pushed the claim that Robinhood was owned by Citadel and that it also owns Melvin Capital, which would benefit from a fall in GME's price. On Monday, Melvin Capital announced it had received an investment to the tune of $2.75 billion from Citadel and Point72 Asset Management, which according to the Wall Street Journal was an emergency influx of cash to, quote, stabilize the hard-hit firm. Therefore, Citadel does have a stake in the investment management company. However, as far as the claim of ownership of Robinhood is concerned, we can confirm that Citadel does not own the trading platform. According to a June Financial Times report, $39 million of Robinhood's revenues from equities and options order flow came from Citadel Securities, a subsidiary of Citadel. This made up more than 35% of the platform's trading revenues at the time. Dude, I don't know. Wow, okay. According to Investopedia, Robinhood is a discount brokerage that offers commission-free trading through its website and mobile app and generates its income from payments for order flow. In simpler terms, Citadel is one of the trading platform's biggest customers. Therefore, the claim that the company founded by billionaire Ken Griffin owns Robinhood can be flagged as, quote, untrue. Yeah, but there's a perverse interest in there. There's a perverse incentive, specifically concerning the trading positions of the other companies or other organizations rather, that Citadel is propping up with their funds. Just because literally, just because it's not written on paper that one owns the other, it doesn't mean that the 35% of their trading flow isn't going to be missed if they were to stop trading. You see what I'm saying? There's a perverse interest here. Anyway, continuing on. Citadel issues statement refuting rumors. Citadel also released a statement saying that it had nothing to do with Robinhood's suspension of trading on the stocks. Quote, Citadel is not involved in or responsible for any retail broker's decision to stop trading in any way, a spokesperson for the hedge fund said in a statement obtained by Fox News. Quote, Citadel Securities has not instructed or otherwise caused any brokerage firm to stop, suspend, or limit trading or otherwise refuse to do business, the statement added. Quote, Citadel Securities remains focused on continuously providing liquidity to our clients across all market conditions. Yeah. Let's see if there's any conversation on this one. I think it's too easy. It's too easy to be able to point at this situation and say, oh, we don't really have an interest here. It just represents 35% of the transaction flow going through Robinhood. No, but we don't really have an interest. You need a fucking break. So, yeah, I think that lawsuits against these guys will be successful. As a matter of fact, I got it right here. And this is on from the United States District Court, Southern District of New York, civil docket, blah, blah, blah. I'm not going to read all of that. Plaintiff, and this is a class action complaint, Robinhood Financial LLC, against them. The plaintiff, Brendan Nelson, and the defendants is Robinhood Financial Securities and Markets. Plaintiff demands a trial by jury. Yeah, that's not going to help you. Nature of the action. Number 1, Robinhood is an online brokerage firm. Number 2, Robinhood purposefully, willfully, and knowingly removed the stock GME from its trading platform in the midst of an unprecedented stock rise, thereby depriving retail investors of the ability to invest in the open market and manipulating the open market. Parties. Plaintiff Brandon Nelson was and is a citizen of the Commonwealth of Massachusetts. 4. Defendant Robinhood Financial LLC is a Delaware corporation with its principal place of business at 85 Willow Road, Menlo Park, California 94025. It is wholly owned subsidiary of Robinhood Markets, Inc. Robinhood Financial LLC is registered as a broker-dealer with the U.S. Securities and Exchange Commission, SEC. Defendant Robinhood Financial LLC acts as an introducing broker and has a clearing arrangement with its affiliate, Defendant Robinhood Securities LLC. Number 5. Defendant Robinhood Securities LLC is a Delaware corporation, and they do that for tax reasons too, with its principal place of business at 500 Colonial Center Parkway, Suite 100, Lake Mary, Florida. and that's another tax dodge thing. 32746. It is a wholly owned subsidiary of Defendant Robinhood Markets, Inc. Defendant Robinhood Securities, LLC is registered as a broker-dealer with the SEC. Defendant Robinhood Financial, LLC acts as a clearing broker and clears trades introduced by its affiliate Defender Robinhood Financial. Interesting. Continuing. Number 6. Defendant Robinhood Markets, Inc. is a Delaware corporation with its principal place of business at 85 Willow Road, Menlo Park, California 94025. Defendant Robinhood Markets, Inc. is the corporate parent of Defendants Robinhood Financial, LLC and Robinhood Securities, LLC. 7. The above-named corporate defendants herein referred to collectively as, quote, Robinhood. Jurisdiction and venue. 8. This court is or has subject matter jurisdiction over this action pursuant 28 U.S.C. 1332D subsection 2, I guess. The aggregate claims of all members of the proposed class and subclasses are in excess of $5 million, exclusive of interest and costs, and there are more than 100 putative class members. Many members of the proposed class are citizens of the state different from the defendant. Number 9. Pursuant to 28 U.S.C. 1391, this court is the proper venue for this action because a substantial part of the events, omissions, and acts giving rise to the claims herein occurred in this district, where Robinhood distributed, marketed, advertised, and sold the trading services which are the subject of the present complaint. Finally, venue is appropriate in this district pursuant to 28 U.S.C. 1391b2 because a substantial part of the acts and omissions that gave rise to this complaint occurred or emanated from this district. What the hell is going on? I got something playing in the background here. You fuckers. Stop it. Don't do that. Fuckers. Now, let's see. Did we finish number 9? Proper venue for the action, blah, blah, blah. Robinhood distributor market. Yeah, we got that one. Okay. 10. This court has personal jurisdiction over Robinhood because it is authorized to do business and does conduct business in New York, and because it has specifically marketed, advertised, and made substantial sales in New York, and has sufficient minimum contacts with this state and or sufficiently avails itself of the markets of this state through its promotion, sales, and marketing within this state to render the exercise of jurisdiction by this court permissible. Factual allegations. 11. Robinhood is an online brokerage firm. Its customers place securities trades through the firm's website by using a web-based application or app. Robinhood permits customers to purchase and sell securities, including futures contracts. Number 12. Robinhood has experienced significant growth as a relatively new online brokerage firm. In 2019, Robinhood raised $323 million in funding at a $7.6 billion valuation. The firm markets itself primarily to younger investors and claims over 10 million users of its trading app. 13. On or about March 23, 2016, Robinhood's official Twitter account stated, quote, "Let the people trade." They have since disregarded their mantra and have blocked access for millions of its customers to trade particular securities. 14. On or around January 11, 2021, stocks in GameStop Corp. began to rise. 15. At that time, Robinhood allowed retail investors to trade GME on the open market. 16. On or about January 27, 2021, Robinhood, in order to slow the growth of GME and deprive their customers of the ability to use their service, abruptly, purposefully, willfully, and knowingly pulled GME from their app, meaning retail investors could no longer buy or even search for GME on Robinhood's app. 17. Upon information and belief, Robinhood's actions were done purposefully and knowingly to manipulate the market for the benefit of people and financial institutions who were not Robinhood's customers. 18. Since pulling the stock from their app, GME prices have gone up, depriving investors of potential gains. 19. Additionally, in the event GME goes down, Robinhood has deprived investors of shorting GME in hopes the price drops. 20. In sum, Robinhood has completely blocked retail investors from purchasing GME for no legitimate reason, thereby depriving retail investors from the benefits of Robinhood's services. 21. The Financial Industry Regulatory Authority, FINRA, which governs brokers like Robinhood, espouses Rule 5310 regarding, quote, best execution and interpositioning. Rule 5310.01 requires that Robinhood, quote, must make every effort to execute a marketable customer order that it receives promptly and fully. By failing to respond at all to customers placing timely trades and outright blocking customers from trading a security, Robinhood has breached these, among other obligations, and caused its customers substantial losses due solely to its own negligence and failure to maintain adequate infrastructure. 22. Robinhood continues to randomly pull other securities from its app for no legitimate reason. 23. Upon information and belief, Robinhood is pulling securities like GME from its platform in order to slow growth and help benefit individuals and institutions who are not Robinhood's customers but are Robinhood large institutional investors or potential investors. Plaintiff's experience. 24. On the morning January 28, 21, plaintiff used his Robinhood app, searched for GME on Robinhood's app, and found it was unavailable. The stock did not even appear, although GME is a publicly traded company available on all other platforms. 25. Thus, plaintiff, like so many others, lost out on earning opportunities. Class action allegations. 26. Plaintiff brings claims pursuant to Federal Rule of Civil Procedure 23 on behalf of the following class as defined below: all Robinhood customers within the United States. 27. Additionally, or in the alternative, plaintiff brings claims pursuant to Federal Rule of Civil Procedure 23 on behalf of the following subclass as defined below: all Robinhood customers within the United States who were not able to execute trades on GME after Robinhood knowingly, willfully, and purposefully removed it completely from their platform. 28. Excluded from this class are the Robinhood entities and their current employees, counsel for either party, as well as the court and its personnel presiding over this action. 29. This action has been brought and may properly be maintained as a class action against Robinhood pursuant to the provisions of Federal Rule of Civil Procedure 23. 30. Numerosity. The precise number of members of the proposed class is unknown to plaintiff at this time, but based on information and belief, class members are so numerous that their individual joinder herein is impracticable. Based on information and belief and publicly available reports, class members number in the hundreds of thousands and up to 10 million. And you know what, dude? You're probably only talking about American customers. There were people from fucking India signing up with Robinhood just so they can get in on that action. Continuing on. Subclass members are likely in the thousands. All class members may be notified of the pendency of this action by reference to Robinhood's records or by other alternative means. 31. Commonality. Numerous questions of law or fact are common in the claims of plaintiff and the members of the proposed class. These common questions of law and fact exist as to all class members and predominate over questions affecting only individual class members. These common legal and factual questions include, but are not limited to, the following. A. Whether Robinhood knowingly failed to provide the financial services that were needed to handle reasonable customer demand, including trading securities that are available on every other competitive trading platform. B. Whether Robinhood failed to provide a duty of care to their customers when they purposefully removed GME. 6. Whether Robinhood removed GME purposefully to harm their customers' positions in GME and benefit their own potential financial gains. That one is really likely. And that one, they should consider possibly an extension to entities that own Robinhood or own stake in things like Melvin or... yeah. Anyway, continuing on. D. Whether Robinhood violated FINRA Rule 5310 among other FINRA rules, state rules, and federal regulations. E. Whether Robinhood violated consumer protection laws in failing to disclose that its services would not include the ability to trade on GME and other securities for substantial periods of time. And that's a big one too. All right, and when you're contrasting things like Robinhood versus the open crypto market, I know that Robinhood doesn't have a whole lot of fees or anything, but if I can make more money on fucking some DeFi platform somewhere, then where do you think I'm going to go? I'm going to go to it. Fuck this bullshit. F. Whether Robinhood was in breach of its legal, regulatory, and licensing requirements by failing to provide adequate access to financial services. G. Whether Robinhood was in breach of its contracts and or the implied covenant of good faith and fair dealing in connection with its failure to provide financial services. H. Whether Robinhood was negligent or grossly negligent by failing to provide financial services in a timely manner due to its own possible nefarious desires. I. Whether Robinhood breached its fiduciary duties to customers by failing to provide adequate access to financial services. J. Whether Robinhood was unjustly enriched by its conduct. K. Whether plaintiff and the other class members were injured by Robinhood's conduct, and if so, the appropriate class-wide measure of damages, restitution, and other appropriate relief, including injunctive relief. Oh, you sons of bitches. I'm gonna have to close that fucking article. Fuckers. I. Whether plaintiff and the other class members are entitled to injunctive and declaratory relief. 32. Typicality. The claims of the named plaintiff are typical of the claims of the proposed class, in that the named plaintiff was a customer during the class period and was unable to trade GME and place time-sensitive trades on GME and sustain damages as a result of Robinhood's wrongful conduct. 33. Adequate representations. Plaintiff will fairly and adequately represent the interests of the class in that he has no conflicts with any other class members. Plaintiff has retained competent counsel experienced in prosecuting complex class actions, including those involving financial services, and they will vigorously litigate this class action. 34. Predominance and superiority. There is no plain, speedy, or adequate remedy other than by the maintenance of this class action. A class action is superior to other available means, if any, for the fair and efficient adjudication of this controversy. Prosecution of separate actions by individual class members would create the risk of inconsistent or varying adjudications establishing incompatible standards of conduct for the defendant. Additionally, given the relatively modest damages sustained by most individual class members, few, if any, proposed class members could or would sustain the economic burden of pursuing individual remedies for Robinhood's wrongful conduct. Treatment as a class action will achieve substantial economies of time, effort, and expense, and provide comprehensive and uniform supervision by a single court. This class action presents no material difficulties in management. I think that this is probably one place where I really have a problem with class action suits, because the people that end up really losing out are the biggest stakeholders. I think if anything, they should allow some sort of comment period when determining any kind of cash settlements or anything like that. That the plaintiffs in the class should be allowed to submit their records of and actually they shouldn't even have to do that. They could probably get it from Robinhood's records. The exact time frame that people had stocks, the direction of their positions, i.e. what they were betting on, and exactly what they would have lost out on. Now, if a plaintiff could propose additional claims on top of that, I don't think that would be very prudent, but at least for the time period. If you can demonstrate that this was your previous strategy and that you would have been observing it during that same time frame, I think that's one thing. But if you were to try and project it forward to say now, that would be a bit of a stretch. But like I said, if for the trading action that you were performing before, according to Robinhood's own records, and apply the standard, for that period ahead, so extrapolate it out over the period that the trader was unable to trade and the direction of their positions given their past behavior. I think that's probably the most just way to handle any kind of cash disbursements, because like I said, they could just take the total number and divvy it up amongst the class members, and you're going to have some people that get more than they initially put in or more than they should have or would have, and some that get way less. Because I guarantee you, there were some outlier traders swinging around some massive dick during that period, or would have been. Anyway, continuing on. Class members fee if proposed members, blah, blah, blah. Treatment, we got that. 35. Class action certification is warranted under Fed R Civ P 23, subsection B, 1A, because the prosecution of separate actions by individual members of the proposed class would create a risk of inconsistent or varying adjudications with respect to individual class members, which may produce incompatible standards. Yeah, we got that already. Okay. 36. the prerequisites to maintaining a class action for injunctive or equitable relief pursuant to Fed R. Civ P 23b2 are met, as Robinhood has acted or refused to act on grounds generally applicable to the class, thereby making final injunctive, declaratory, or equitable relief appropriate with respect to the class as a whole. 36. Class action certification is also warranted under Fed R. Civ P 23b3 because questions of law or fact common to the class members predominate over any questions affecting only individual members, and a class action is superior to to other available remedies for the fair and efficient adjudication of this controversy. The amount of damages available to the individual plaintiff is insufficient to make litigation addressing Robinhood's conduct economically feasible for most in the absence of a class action procedure. Individualized litigation also presents a potential for inconsistent or contradictory judgments and increases the delay and expense to all parties and to the court system presented by the legal and factual issues of the case. By contrast, the class action device presents far fewer management difficulties and provides the benefits of a single adjudication, economy of scale, and comprehensive supervision by a single court. 37. Class action certification is also warranted under Fed R. Civ P 23c4 because questions of law or fact common to the class members may be certified and decided by this court on a class-wide basis. 38. Plaintiffs hereby incorporate by reference the factual allegations set forth above. 39. In order to use the Robinhood trading platform, a potential customer must enter into the customer agreement with Robinhood. 40. Plaintiff and all class members did enter into a customer agreement with Robinhood. 41. Robinhood breached its customer agreement by, among other things, failing to disclose that its platform was going to randomly pull a profitable stock from its platform, that Robinhood failed to provide adequate explanation to their customers, that Robinhood knowingly put their customers at a disadvantage compared to customers who used other trading apps, that Robinhood failed to provide access to its own financial incentives to pull certain securities, including GME, that Robinhood's prohibited plaintiffs from performing in a timely manner or at all under the contract, that Robinhood failed to comply with all applicable legal, regulatory, and licensing agreements, and that Robinhood failed to exercise trades and actions requested by customers. 42. As such, Robinhood breached its customer agreement with plaintiff and class members. 43. Robinhood's failure to perform and its breaches of the customer agreement resulted in damages and losses to plaintiff and class members and continues to expose them to harm because Robinhood continues to fail to perform under the customer agreement. These losses reflect damages to plaintiff and class members in an amount to be determined at trial or separate proceedings as necessary. Good. That creates the possibility for them to expand the time window of effect, and so that would come into consideration when they're trying to determine the adjudication amount. So like if they're going to give people money, determining the time window to be considered. Anyway, continuing on. Class Action 2. Breach of implied covenant of good faith and fair dealing. 44. Plaintiffs hereby incorporate by reference the factual allegations set forth above. 45. Plaintiffs and members of the class and subclass entered into the customer agreement with defendant Robinhood to open a Robinhood trading account. They agreed to Robinhood's terms and conditions by using Robinhood's website and trading platform. 46. Plaintiffs and members of the class and subclass fulfilled their obligations under these contracts by adhering to their terms and using Robinhood's trading services through its website and trading platform. 47. Robinhood was obligated to provide the trading services required under those contracts at all times, including but not limited to trades for GME. 48. When initially signing up for Robinhood, plaintiff and all those similarly situated could and most actually did trade GME. So I would argue that a good number of them signed up with Robinhood specifically to trade GME. 49. Robinhood unfairly interfered with the rights of plaintiffs and members of the class and subclass to receive the benefits of the customer agreement by, among other things, 1. Failing to provide services necessary to carry out a trade, 2. Failing to provide certain trading services whatsoever, 3. Failing to inform individuals in a timely member of the timely manner of the drastic changes in trading abilities, and 4. Prohibiting plaintiffs from buying GME for Robinhood's own pecuniary interest and not disclosing those interests to plaintiffs and all class and subclass members. 50. Robinhood's conduct has caused plaintiffs and members of the class and subclass harm, losses, and damages. These losses reflect damages to plaintiffs and members of the class and subclass in an amount to be denominated or to be determined at trial or separate proceedings as necessary. Cause of action: negligence. 51. Plaintiffs hereby incorporate by reference the factual allegations set forth above. Robinhood had a duty to exercise reasonable care in conducting and facilitating transactions for its customers. 52. Robinhood had a duty to exercise reasonable care in providing trades on the free open market for its customers. 53. Robinhood unlawfully breached its duties by, among other things, 1. Removed GME without notice from its trading app. 2. Failed to provide financial services related to GME. 3. Failing to notify customers in a timely manner of the GME blackout. 54. Robinhood's conduct as set forth in this complaint was want of even scant care, and its acts and omissions were and continue to be an extreme departure from the ordinary standard of conduct. Their actions breach any duty of care to their customers, but are also inconsistent with the standard of care expected from similar firms in the open market. 55. Upon information and belief, no institution similar to Robinhood has ever outright banned customers from purchasing a specific share of a specific security. 56. Robinhood essentially abandoned its customers altogether by pulling GME, a standard of care so far below what is required for a business engaging in time-sensitive trading services that it amounts to a complete abandonment of its duties. 57. Robinhood's grossly negligent and wrongful breaches of its duties owed to plaintiffs and members of the class and subclass approximately caused losses and damages that would not have occurred but for Robinhood's gross breach of its duty of due care. These losses reflect damages to plaintiffs and members of the class and subclass in an amount to be determined at trial or separate proceedings if necessary. The plaintiff hereby incorporates by reference the factual allegations contained herein. 59. As a licensed provider of financial services, Robinhood, at all times relevant herein, was a fiduciary to plaintiff and class members and owed them the highest good faith and integrity in performing its financial services on their behalf. Robinhood also acted as a fiduciary to each and every customer who agreed to the customer agreement. 60. Robinhood breached its fiduciary duties to plaintiff and class members by, among other things, failing to disclose that its platform was going to remove GME purchases in a timely manner, actually removing GME for its own pecuniary benefits, that Robinhood failed to provide access to its financial services in a timely manner, that Robinhood failed to comply with all applicable legal, regulatory, and licensing requirements, and that Robinhood failed to exercise trades and actions requested by customers in a complete and timely manner, also required by FINRA Rule 5310. 61. Robinhood's conduct has caused plaintiff and class members harm, losses, and damages, and continues to expose them to harm because Robinhood continues to breach its fiduciary duties. These losses reflect damages to plaintiff and class members in an amount to be determined at trial or separate proceedings as necessary. Relief request. Either an immediate injunction requiring Robinhood to reinstate GME on their trading platform. Number 2, an award for plaintiffs to be determined. Number 3, enter an award for attorneys' fees and costs. 4, enter an award for punitive damages for the willful, wanton, and reckless behavior of defendants. Number 5, any other relief this court deems just and fit. And that was dated January 28th, 2021. Respectfully, Alexander G. Cabasarius, Esquire. New York. Yeah, okay. So, there you have it. It was a pretty significant case. I think this will have really interesting implications going forward. You know, for one thing, I think that the fact that they have and can exercise this level of censorship on your transactions occurring on their platform, again, is one of those things where it's like it's within their capability as a fiduciary, but it's their exercise of that capability that will determine how they are actually brought to account, and they will be brought to account for it, and maybe not specifically by the court, but I do see that they're going to be made to eat some fucking turd. I mean, at least in my book, they should, you know, because that's not right. It's just not right. And I mean, who are you to tell the market no? Who the fuck are you to do that? And if you can tell the market no, why am I trading on that market? Why don't I find one where you don't have any fucking influence and you can't fucking say no to me? You want to talk about something that will initiate a transition of traders from legacy markets to almost explicitly and exclusively cryptocurrency markets. It's exactly this kind of fuckery. Anyway, let's go ahead and throw back down with some music. And so here we go. A little bit of Voivod for you. The End of Dormancy. Here on Coin Metal. And that was Nevermore. And for some stupid reason, I didn't get the metadata off that song yet. But it was off of, let's see, what album was this? Dreaming Neon Black, and it was track 5. Sorry, I couldn't tell you exactly which one it was. Man, I gotta fix that, because I really like everything on that album, and or at least most of it. And I don't have that fucking metadata, so I don't know where to stuff it into the show, you know? I mean, track 5, what the fuck is that, right? Anyway, as far as what else we're going to get into here, yeah, I'm going to go with this one. It's an article by Bloomberg, and a little bit more on what we're doing here, or talking about here. Robinhood users suing over trade limits face high legal bar. And this is authored by Chris Dolomich, Christopher Isijico, and Christian Berthelsen. So, triple penis? It was authored on January 28th, 2021 at 8:47 a.m. PST. Frustrated investors who sued after getting locked out of trading in frenzied shares like GameStop Corp aren't likely to have much luck in court either. Online brokerage Robinhood Markets was named as a defendant Thursday in several federal suits, demanding it reinstate trading of shares including GameStop, BlackBerry Ltd., Nokia, OYJ, and AMC Entertainment Holdings, Inc. Just hours earlier, Robinhood Interactive Brokers and others took steps to curtail activity in the high-flying stocks after several dizzying days of trading on their platforms whipped up volatility. While users of the trading platforms claim in court filings that they suffered losses from the restrictions, legal experts say brokerages have broad powers to block or restrict transactions, all of which is spelled out as part of customer agreements everyone signs to gain access to the services. Quote, I'm looking at the Robinhood contract, and it says in black and white they can block or restrict trades at any time, said Jeff Ayres, who runs a Miami-based law firm specializing in securities fraud litigation and represents plaintiffs in a lawsuit filed last year against Robinhood related to service disruptions. Quote, I'm not aware of any law that would guarantee you a right to purchase a certain security at a certain brokerage firm. No, it's not a right, and you know what? You are right that they have that power. But the assumption is that they're not going to utilize that power to punish you, their customer, and specifically to benefit someone else who may be one of their institutional investors, and prioritizing them over the quote-unquote retail investors. You know, it's extraordinary bad faith, I think. And in all honesty, I would suggest that anybody who was serious about their trading, you know, who wasn't just doing it to fuck off or whatever, but who's actually trying to make money, and who's actually wanting to like use a broker dealer such as Robinhood, who isn't going to censor your transactions, or certainly won't do it just to benefit some other traders. Anyway, continuing on. Maverick traders. The legal fight comes after a group of maverick, digitally oriented traders who gather in Reddit's Wall Street Bets forum sent shares of GameStop and other companies soaring with the apparent goal of earning millions of dollars in profits and causing billions in losses to hedge funds that were shorting the stocks. In a lawsuit filed in New York, Robinhood user Brendan Nelson of Massachusetts said the company removed GameStop from its trading platform in the midst of an unprecedented stock rise, depriving individual investors of the ability to invest and manipulating the market. The decision was a breach of its customer agreement and was in violation of financial industry rules, according to the complaint. And we got that. In a Chicago lawsuit, Robinhood user Richard Joseph Gatz of Napier, Illinois, said the halting of trading in BlackBerry, Nokia, and AMC, quote, was to protect institutional investment at the detriment of retail customers and is in lockstep with other trading platforms. Quote, the halt of retail trading for these stocks has caused irreparable harm and will continue to do so, Gatz said. Robinhood Chief Executive Officer Vlad Tenev denied the company had been pressured into curtail trading in the stocks by institutions. No, you were driven to do it by your fucking pocketbook. Continuing on. Quote, we weren't directed by a market maker or any other market participant. Yeah, you're full of shit. Tenev said in an interview with Bloomberg Television, quote, this was a technical and operational decision we made. No, it wasn't. What it was your provider, the group that does your transactions for you, said, no, we're not going to do these trades because they're against our other positions. Fuck you. He said the company's financial requirements, such as deposits to clearinghouses, increase when there's a lot of volatility in the market. So, quote, to protect the firm and to protect our customers, we temporarily disabled buying in these securities. Other client suits were filed in Florida, California, and New Jersey, and New York Attorney General Letitia James said that her office is, quote, aware of concerns raised regarding activity on the Robinhood app, including trading related to the GameStop stock. We are reviewing this matter. Robinhood has faced criticism in the past for allowing relatively unsophisticated traders to engage in risky trades that resulted in massive losses, and some commentators have expressed concern about the losses that individual investors are likely to suffer when the Reddit-driven bubbles burst. Dude, you cannot save people from their own stupidity. I'm sorry. Every effort that you do to try and criminalize stupidity just results in more stupidity. Continuing on. Broad discretion. Brokerages are permitted broad discretion in limiting trades to provide flexibility in handling unusual situations, like technical glitches, mechanical errors and mistakes, or to preserve an orderly market, said Columbia Law School professor Joshua Mitz, who specializes in corporate law. Quote, there is no obligation that a broker-dealer has to unconditionally accept orders to buy, sell, or short-sell securities, said Cam Funkhauser, a former executive at the Financial Industry Regulatory Authority, FINRA, a Wall Street-backed regulator that oversees broker-dealers. Quote, if they do accept orders, it is expected that the transaction is executed and settled in compliance with the applicable rules, said Funkhauser, who worked at FINRA for 35 years and oversaw its National Fraud Detection Office. Dude, this fucking fraud happening in front of your face, and you're not calling it fraud. They're giving preferential treatment to institutional investors over retail investors due to their own financial interests. I mean, how hard is that to figure out? I mean, you literally have to be like blinding yourself intentionally to the entirety of the case and those affected and how. Continuing on. The lawsuits, quote, are likely subject to dismissal based on customer agreement language, Elliot Stein, a senior litigation analyst at Bloomberg Intelligence. I think you're full of shit. They knowingly engaged in this shit specifically to harm their retail investors. And honestly, I believe in that language in the lawsuit that we read, that it was specifically to do that. It wasn't for any fucking technical reason. Why would they be so selective in the securities that they bothered to do this to? What was the interest in doing one and not the other? I mean, really, were you receiving the trade volume so hard and heavy that you just couldn't document it properly? I mean, that's an acceptable possibility, but it's not all that likely. Continuing, it is understandable that many investors are upset by the sudden restrictions to trade certain stocks, especially if they didn't read their user agreements very carefully, said Tom. Dude, they shouldn't have to be a fucking lawyer to understand that shit. Continuing on, said Tomlin, a law professor at Temple University's Beasley School of Law, whose specialties include securities regulation. Quote, whether brokerages should exercise that power in the current circumstances is up for legitimate debate. There is likely so much more to this story than we know at the moment. Yeah, you know what? I believe that the thing is so deep that the repositioning that Melvin was doing was going from shorts to long positions. And so they made money until we caught up with them on the shorts and started squeezing that. Then they terminated those positions, repositioned long, and made money on the way back up. Continuing on. Depends on the situation. Still, while user agreements, quote, tend to be pretty broad in allowing brokerages to decline working with anyone, they aren't always an absolute protection from aggrieved clients, said Timothy Blood, a partner with Blood, Hertz, and Reardon in San Diego, who has represented investors in disputes with brokerages. Quote, it's going to depend on the particular situation that arises, Blood said. There might be a liability if a brokerage allows trades by some clients, but not by others, especially if the one being denied needs access to the market to complete a long-term strategy with additional trades, Blood said. Quote, if a long-term plan gets cut off midstream, the clause helps Robinhood but won't be the last word on the issue, he said. Double standard? Quote, I think it's extraordinarily rare for brokers to halt that trading without a determination by regulators that it was necessary, said Adam Ghana at the National Securities Arbitration law firm Ghana Weinstein. The surge in share prices was the result of, quote, a band of investors getting together to purchase a security, not some, quote, insider collusion pumping up the price, he said. The filing of lawsuits tells me that the broker-dealers who stopped trading by their own volition are potentially going to be in a lot of trouble, both on a regulatory level and on a civil litigation level, he said, and I agree. While Robinhood's customer agreement clearly states that it can suspend trading at any time, it does raise questions about whether the platform treated some users differently than others, especially after cases in the past decade of market manipulation by short sellers that disadvantaged retail investors, said Mitz, the Columbia Law School professor. Quote, when the hedge funds are going to lose from a trading suspension, they don't face any lockup like this, any suspension, any halt at the retail level, Mitz said. Quote, but when retail investors find themselves locked in, they find themselves unable to exit the trade. And yeah. So, there you have it. You know, I think I've stated my position on it, but I mean, I'm not a legal expert or anything like that, so really, don't try dragging me to court as an expert witness. Well, I don't know, I could probably sub for like a knowledgeable witness. I won't ever claim to be an expert in this shit, but you know, I've seen some shit, man. Anyway, it is with that I'd like to bring this episode to a close. Thank you very much for listening. I certainly do appreciate the support. We will be back again on Monday at 8 p.m. Pacific Standard Time, and so until then, I want y'all to trade safe. Do your homework. And watch out for your own bunghole, because nobody is going to do it for you. And so as far as our last dance is concerned, I have not picked anything out, but we'll find one. We'll find an appropriate one. No. No, that's not it. Damn it, Jim. No, we already played that. We already played that. Man, we played a lot of good stuff today. It's taking away all my good ideas for Last Dance. What the fuck? Here we go. We'll give this one to an oldie but goodie. Judas Priest, Electric Eye. Last Dance here on Coin Metal. Thank you again for listening, and y'all have an excellent weekend. Good night.